This is it's 10:02 on August 30th.
Recording in progress.
Okay, I'll say that again. It's August 30th, 2023. We're in Monterey County in Newport at the PUD with a hearing with, let me just hang on here. Responsible growth, Northeast Washington and Spokane River Keepers versus Monterey County. This is case number 23-1-0005. My name is Bill Hinkle. I'm the presiding officer. To my left is Jim Mura. He's Western Region member of the board. There's only 3 of us right now. Our third member has a conflict, so there'll just be 2 of us on this case. Hearing and coming up. So we have Zachary Griffin, and for the petitioner, Nathan Smith for the county.
The county did not analyze the impacts of allowing new single-family residential development along single ingress and egress roads in forested lands within the wildland-urban interface. The wildland-urban interface is sometimes called the WUI. It's the area where a built environment intersects with or meets with a natural environment. Human settlements in the WUI are at greater risk of catastrophic wildfire. The county did not even map the wildland-urban interface, let alone consider it in this action.
Okay, I have a question for you. Is that required by GMA?
The GMA requires, the SEPA requires that the county analyze the probable significant adverse impact. So it was required under SEPA.
But mapping is not required in law, correct?
Under the GMA, there is no specific requirement that I am aware of to map the wildland-urban interface.
That's all I need, thank you.
The board should vacate the county's SEPA determination of non-significance and order the county to prepare an EIS.
Mr. Griffin, on the SEPA issue, the county says, per Office of Financial Management, population growth through 2039 is likely to be, I think they said, 45 persons per year. Is that in dispute?
That is not in dispute.
So that's, I would say, most people would see that's a pretty slow rate of growth, pretty minimal growth, 45 persons per year. Is that is that sprawl? Is that, unplanned growth, or is that just a very, to my impression, it'd be a very slow rate of growth? So is that significant impact of that, allowing that level of growth to continue?
That may be a significant impact because it's not only the growth in population that's at issue, but the allowance of new, never before permitted uses in areas where they were never permitted before.
Residential uses is largely what you're objecting to, right?
Also industrial and commercial uses, okay, which were not land use designations before this resolution, and now they are.
But the residential uses appear to be minimal.
It depends on where they are in large part. So, for instance, existing residential uses must comply with wetland and riparian habitat area buffers. The county is slashing those buffers significantly so that even if there were no population growth within the county, the existing residents of the county would be allowed to encroach much more closely to critical areas than was the case before the resolution. They will also be allowed to build in areas where single-family residential development was not allowed before the resolution.
Well, that in itself is not a violation of GMA. So you said this a number of times about industrial growth, industrial uses, residential. So how does that violate the growth management? Just a change in use is not in itself a violation.
For a start, the county nowhere defines rural character in the resolutions or in the resolution in the comp plan or in the development regs. In response to our argument on this point, the county lists a number of public hearings and land use policies, but lists of land use policies and public hearings do not show that the county defined rural character. County's response brief does not point to anywhere where the resolution defines rural character, because that definition is not found in the resolution or the comp plan.
Does the GMA require a definition of rural character or require that the county establish patterns of rural development?
The GMA requires a written record that shows how when the county considers local circumstances, it must prepare a written record that shows how the provisions that it's considering harmonize with the goals of the GMA and the rest of the plan. And this plan states as a goal, I don't have the direct quote in front of me, but protect and preserve rural character.
Right, not define it. I mean, you're harping on the fact that they failed to define it.
Yes, I am harping on the fact that they failed to define it, because you can't establish harmony with something or protect something unless you have defined that thing first.
Okay.
Inexplicably argues that it did adopt an amended table of permitted uses, but the draft 2020 TOPU, table of permitted uses, which is the most recent draft there is, allows commercial and light industrial uses in rural and rural residential areas as conditional uses without assuring conditions that will be imposed to protect rural character as required by the statute 3670A079.
I think that's a stretch. So the essence of the conditional use process is to protect rural character, or to protect the foundation of the existing land designated. Just so I didn't make a conditional use. So explain to me how that does that. Just saying it doesn't mean it's so. I know you make to quote him, you make a lot of declaratory statements without citations. So I'd like to actually see what you're talking about, because that doesn't make sense to me.
Yes, it's no here.
Okay, I'm just telling you.
Thank you.
Okay.
Moving on from the TOPU, the newly adopted Rural Land Use Policy number 10 violates RCW 3670A 110 sub 1 by requiring the adoption of zoning classifications, quote, to direct commercial uses to more populated areas of the county, end quote, without ever specifying that those more populated areas should be urban growth areas, and without precluding urban type commercial uses outside of urban growth areas.
Just as an aside, how many and which UGAs exist in the county?
I'm not sure of the answer to that. I think there's 2, but I'm not sure that's correct. That the resolution adopted by the county does not contain assurances that they will be visually compatible with adjoining or adjacent rural uses, rural areas, excuse me. So the GMA should put side rules on the newly authorized PUDs that are enforceable and that assure visual compatibility. So, for instance, if it says should provide 50% of opacity, a vegetative buffer should provide 50% opacity, that does not assure visual compatibility with surrounding rural areas. And I think that we can anticipate that even if the overall density of the PUD is the same as individual single-family homes scattered over a number of parcels, if that density is concentrated next to a road, say, or near the beginning of an access road off a bigger road, the visual impact of that will be great because the public will see, and existing residents will see the PUD and not the acres of land set aside behind the PUD further away from thoroughfares.
So I understand that. That in itself, how is that a real violation? Well, this is kind of, the supposition is that we're making the GMA assumes that regulations are legal and the standard until we have this hearing, and then the burden is on you to show why. And so far, what I hear is you don't like seeing greater density by a road, but maybe they want to see the people that actually buy the lots want to see the land also, and not, I mean, there's all kinds of reasons why you would do that. That in itself, what you just said is, I don't see it as a violation. I mean, this is really a matter of opinion, visual compatibility. So what you're saying is we should never do in rural areas, never have any 1 acre lots or small acre lots along the road.
No, sir, that's not what I'm saying.
That's what it comes across as. I'm just telling you, it doesn't make sense to me.
Okay.
So let's clear that up.
Mr. Chair, what we're saying is that PUDs were not allowed before. The PUDs are new in this resolution.
PUDs are an innovative planning technique used in a lot of rural counties.
Yes, sir.
And in itself, it preserves a lot of acreage throughout the state. It's been very successful. So tell me why it's not going to be successful here. Because of visual compatibility, that's a hard one to prove. And, again, what's your standard? What's the standard here? Do you remember?
It's the county's action is presumed correct, and
Clearly erroneous.
you must have a firm and definite conviction that the mistake has been made.
Okay, so help me. I'm not trying to pick on you, but really, I'm not. But I really have to understand this because I didn't see it in the brief. So I really want to understand.
Our argument is that we agree that innovative land use development techniques are not only allowed, but can be good.
Yeah.
PUDs can be good. They do set aside land and preserve land and have a lot of benefits. But when the county created PUDs, it should have put railings or sideboards in the comprehensive plan and in its development regulations that assured that it would continue to protect rural character. And it just didn't do that. It will leave that all for site-by-site, case-specific analysis down the road. And in this GMA action, the county should have, at the outset, assured that when people are proposing PUDs later, they will be visually compatible with the existing rural character.
Okay, you should probably keep going. I've given you an extra 5 minutes.
I just want to follow up.
Okay.
Well, back to where you're saying, you gave the example of, the impact of, distributed housing is not as disruptive of rural character as when they are, congregated in a single area. With another name, that's clustering, which the GMA says clustering is fine. I mean, isn't that what the county is proposing? I mean, in short, well, clustering is what you were telling us is, well, that's going to have a terrible impact on visual character in the rural area. Clustering is spelled out in the GMA as appropriate.
We're not saying that clustering or PUDs are necessarily going to have a terrible impact.
Right.
At all. We're saying that the county should have taken steps now to assure that they don't. And they could have. They could have put language in the new PUD provisions that are authorized by this action to assure that they will be visually compatible and meet the other requirements of the GMA. And they just didn't. And our argument is you should have included language that assures that when you authorized PUDs.
Just based upon your familiarity maybe with other jurisdictions, what sort of assurances do jurisdictions commonly use that meet GMA scrutiny?
I would have to get back to you on that. I haven't had a PUD.
Yeah, and I don't mean to put you on the spot on that, but you're saying the county didn't do anything to assure rural protection of rural character. And so I'm thinking, what are you suggesting that they should have done? And again, we can't dictate what they do, and you can't dictate what they do. But I'm just wondering, it's like, sort of as a per example, here's they're allowing PUDs, but they fail to do X, Y, and Z. Not that you could mandate it, not that we could mandate it, but it would certainly help flesh out any potential claim of error, right? They could have done X, Y, and Z just like, Lewis County did, but they didn't. And that's why I'm trying to get my hands around.
The resolution is not consistent with the protection of natural surface water flows and groundwater and surface water recharge and discharge areas. This relates to the permit exempt domestic wells. The Spokane Riverkeeper, Jerry White, with us today, offered testimony to the county on this issue that's found at Record Index number 291. Surface water flows in the county and in the Little Spokane River and in other tributaries to it are fed by groundwater, especially during the summer months. That means, as the Spokane Riverkeeper testified, that many of the sources, and these aquifers are separate from the Spokane Valley Rafton Prairie aquifer. These are smaller, often perched aquifers that feed the surface waters, and this means that many of the sources are small, discrete pockets of groundwater that at once maintain the surface water of the watershed and are vulnerable to human pumping. Because when you dig a well, you dig down until you hit one of these aquifers and then you stop. If that aquifer is giving groundwater to the river, that's a problem.
Okay, so what's the system they have here that is in this county for permitting exempt wells? Because there's a statewide requirement that counties can no longer just check a box and say an exempt well meets the need.
Well, in this county, the county cited to their environmental sensitive areas policy number 5, which calls for developers to document water availability. But that the development regulations do not require that documentation for permit exempt domestic wells. Similarly, in the development regs in this county, XX.52.030 binding site plans states as an approval criteria of sub E2, the applicant shall demonstrate that adequate water rights exist to serve the binding site plan, quote, except when water withdrawal is exempt from obtaining a water right permit under RCW 9044.050. And that statute says that no withdrawal of public groundwaters of the state shall be begun, nor shall any well or works for such withdrawal be constructed unless an application to appropriate such waters, blah, blah, blah.
Listen, I'm from Kittitas County. You don't have to explain groundwater to me.
Okay, so, yes, sir. So you're familiar with the exemption for wells and industrial uses under 5,000.
What system do you have here that's not going to work? That's not going to protect groundwater? Because you make a statement that there could be ground surface water connection, and yet does that mean there's no way that would be caught? There's no way that is evaluated in the permitting process here in the county?
I don't see where that is evaluated in the permitting process for permit exempt domestic wells. I don't see where that is evaluated in the county for industrial uses under 5,000 gallons, 5,000 gallons a day.
And where's the Department of Ecology with that issue? Did they make any comments on this issue at all?
I'm unaware of that.
I'm not aware of they did either. And I can promise you, if there's a problem, they would comment when it comes to groundwater. That they do to every county I've seen. So the lack of their testimony on groundwater concern is remarkable to me. So we'll address this later with the county and try to dig into it more. Maybe in your reply you'll have something too. So
opportunity to comment. Our issue number 26 was adequately addressed in the brief. I'm happy to answer questions about it if you like.
I did have a question on that. So you noted in your brief that you were saying ladies policy number 2 was significantly changed. The comment period closed. I don't know if you specified what actually the change was.
I think we do in the original brief, and just touch on it in the reply brief.
Okay. So what was the change?
It was rewritten substantially and moved to a new new number, and then there was a new number 2. So number 2 was changed and moved, and then a different.
Yeah, and I saw that in the brief, the renumbering, but I guess maybe I failed to understand, my misreading, what was the change?
I can tell you in a moment if you like.
Sure. Yeah, I mean, I remember reading that section of the brief a couple times, scratching my head, trying to figure out.
So in our initial opening brief,
Yeah, I'm looking at page 10 of your
page
brief.
10,
Right,
yes.
it says, after the comment period closed, the county significantly changed the language of rural land use policy number 2. But what did it, and it inserted a wholly new land use policy 2. So what was the difference? And how did it change? And why is that change important to it?
I don't have the red line in front of me. I can respond in about 10 minutes.
Okay, fair enough, yeah.
Let me just make a quick note. I think that the our issues about the former Ponderay newsprint company and the lack of a granular analysis of how that should be protected is likely adequately briefed, but I would like to direct the board to the audio of the May 11th, 2021 Planning Commission meeting. This is record index number 160.
Excuse me, have you transcribed the audio? Because we're not going to listen to audio. We never do.
Yeah.
Unless it's transcribed,
Right.
we don't look at it.
I apologize for not making that clear in the pre-hearing meeting that we had conference. We don't. You have to have that.
I mean, because as a practical matter, it could be a 3-hour hearing, and we can't listen to 3 hours of testimony trying to figure out where that is.
I have a specific timestamp, and it's 3 minutes. It's the statement of Mike Lithgow, who's part of the Kalispell tribe and was speaking for them in that.
Unless it's been transcribed, I mean, that's a pretty much solid policy that the board has. We're not going to. I don't think it's up to Bill whether.
No, I think it's even in our. It's in the WAC, isn't it? That we don't.
Yeah.
It may be that. I think Mike Lithgow was reading from a prepared statement to the Planning Commission.
Maybe that's
and I would like to look for that, and I beg the board to allow me to submit that record index number. If he submitted that statement in writing, I'd like to put it before you because he says it as well as or better than I can.
Any objection?
No objection.
Okay, if you can find it in writing, then we'll accept it.
And when a jurisdiction amends its comprehensive plan or changes zoning, quote, a detailed and comprehensive SEPA environmental review is required. That's a Western Washington Growth Management Hearings Board case, associations, citizens concerned about Chambers Lake Basin. Ponderay County here did both. They amended their comprehensive plan and they changed zoning. But the county did not do a detailed and comprehensive SEPA environmental review. County failed to base its DNS on adequate information regarding a number of things, including the impacts of turning prohibited uses into permitted uses, the impacts to critical areas and wildlife habitat, the impacts of sprawl in rural areas and the attendant increased fire danger, and how climate change would exacerbate these impacts. The county in response says, I don't know. And you base the checklist on your own knowledge. So saying I don't know or not applicable or does not apply are perfectly acceptable answers. But that's true as far as it goes. But that assumes somebody else is going to review those answers and determine whether you've created a gap in necessary information. And here, Greg Snow was both answering, was the applicant, and the responsible official, and was checking his own work. He answered not applicable, non-project action 49 times in the SEPA checklist.
But that in itself is not a violation of SEPA. So what I'd like to know from you is what specific environmental impacts in the record are pointed to that were not addressed. And I mean specific impacts, okay, not suppositions, and not concerns about a certain issue, but what specific impacts?
The wholesale change from conditional uses to permitted uses across the entire county may have a probable significant adverse impact.
What impacts? See, that's the point. You can say it may have an impact, but what impacts are they overlooking?
They are overlooking the impact to critical areas because a conditional use or an existing non-conforming use has to comply with what the county has now reduced in terms of buffers. You can't get a reasonable use exemption for a existing non-conforming use, or I believe a conditional use. But once your use is permitted, you have a reasonable expectation to use your property as other people in your zone use their properties. And if there's a critical area on it, like a wetland, you can seek an exemption from the Sensitive Areas Code to allow you to use your property for this now permitted use. That wasn't available before in large areas of the county and will be available now. So losing the protections of the critical use review process, I can come up with some other examples.
So exemptions to critical areas, again, is not an unheard of thing. In every county they're allowed. And simply saying that you're harming the environment because you have a system that allows exemptions, the criteria for exemptions is very strict. And it's also another place where they can be sued, the county can be sued. So I'm curious, are you familiar with the standards in order to grant a critical areas exemption? Have you looked at that?
I have looked at
In what
that.
way are those exemptions putting the environment at risk?
I've looked at that, but not in this county and not recently. I had a case recently near the city of Medical Lake.
I don't want to hear that.
Okay.
But this is the point here is that simply saying there are exemptions in the critical areas ordinance for new designations in itself is not a SEPA issue unless you can point to a specific environmental impact that will not be covered in the code. And I'd want to know what that is. I mean, it's good to be concerned. This is why we have critical areas. It's also why we have a very strong process, I think, in every county in the state on exemptions. They're not allowed willy-nilly.
I have an example.
Yeah.
Let's say there's a lot, and the entirety or almost the entirety of the lot is covered by either a wetland or the wetlands buffer, making it impossible to site a single-family residential dwelling on that lot.
Mm-hmm.
Further assume that before this resolution passed, single-family residential was prohibited on that lot. No problem. You cannot go build your prohibited home on this lot and go into the buffers. But once you make it a permitted primary use on the lot, then the owner of that lot can say, this is a permitted use here, and I am prevented from making reasonable use of my property because of these wetland buffers. And then I think it's very likely that they would get an exemption to the strict application of the Sensitive Areas Code to allow them to make reasonable residential use. Now that residential use is reasonable.
That's a hypothetical that's a pretty big question. I mean, I'm trying to think of any case that I can remember where they've ignored buffers, established buffers in critical areas in order to build a house in that situation. I mean, that's a hypothetical I've never heard of before, but maybe they're out there.
We argue a lot of those cases.
Your point is made. Yeah, your point is made, and I'll take it into consideration.
And to be fair, they're all hypothetical.
Okay, let me ask you another question. I hate to harp on this, but this is a really important thing. And we're very strict on SEPA, just for the record. As you probably know, you've probably seen recent decisions from us. So I'm really trying to dig into the examples here. When we talk about specific impacts on the record, I think was my first question. In the record, of their decision. In other words, were there any letters of concern from any of the state agencies in regard to this, that they were missing this, or that this had been missed? Was the CFA challenged initially? Any of those things in the record?
I have something in the record that shows a potential impact. It's from the South Ponderay Fire Rescue Organization, not a state agency. But that district, the South Ponderay Fire Rescue, said that, quote, as more land areas become available on the real estate market, the district, that is their fire district, is experiencing additional growth in previously undeveloped areas. This creates new challenges with regards to response times, water supply availability, and interface issues. That's the record index number 276.
I read that. That's I understand that. And of course, let's move on and let you finish.
Thank you.
Okay, we have time for questions. I have actually one question written out, and I'll get to that after my colleague.
I just have one remaining question. Back to SEPA, the DNS. I understand that it was appealed to the county's hearing examiner who upheld the DNS. Procedurally, where does that put the DNS and the board in terms of determining the adequacy of the DNS?
You're reviewing the second hearing examiner decision.
Okay, and I didn't see a lot of argument about the substance of the decision.
That's true. We focused on the substance of the SEPA DNS.
Right. So aren't you asking us though to review the hearing examiner's decision? I suppose, maybe I'm wrong, and determine where and if the hearing examiner committed error?
Yes.
Okay.
And as I'm sure you're aware, there were two hearing examiner decisions.
Right.
We won the first one, at least in part, and our clients were pro se on the second go round, and the hearing examiner upheld the DNS.
Right. Okay. But I didn't see a lot of argument about. So really, our focus then is on the second hearing examiner decision.
Yes.
And I didn't see a lot of argument about why we should reverse the hearing examiner.
That's true. There was not a lot of argument about that.
Okay. It doesn't give us much to work with.